call the May 28th, is it, meeting of the Falmouth Zoning Board of Appeals to order. My name is Ken Foreman. I'm the chair for anyone that doesn't know that. And begin by introducing the board. So to your right is Ed Van Kuren, who's a voting member, your far right, and then John Sutherland, who's an associate member. And next is TJ Hurry, who's the clerk of the board, and then Mark Kuhl, who's also an associate member. The other thing I'd like to remind everyone is to silence your cell phones if you have a cell phone. As I'm sure many of you know, the Zoning Board of Appeals is charged with applying the zoning laws of the town and considering requests for special permits, appeals, and variances as provided by the bylaws, which have been approved by town meeting and by the Attorney General's office. Decisions are made through a public hearing process. Our goal is to hear testimony from the applicants and the public and to allow full and fair discussion of any project prior to rendering a decision. So the process really works like this. To begin each hearing, I'll ask the clerk to read an announcement of the hearing and present any pertinent information from the file, in particular referrals from town departments, perhaps to summarize correspondence quickly. Then the applicant or the applicant's representative will have an opportunity to make a presentation to the board. Our policy is to limit presentations to 15 minutes. If additional time is needed, you can request that, and by vote of the board, you can have additional time. Then the board will question the applicant. The public will be invited to comment at that point after our questions have been answered. And public comments, of course, should be directed only at the project. Please refrain from making personal or derogatory remarks. It's fine to have an opinion in favor or opposed. In fact, we'd like to know that. And again, if discussion starts to get too lengthy, the chair can limit discussion. All of your comments should be addressed to the board, please. If you wish to comment, wait to be recognized and then go to the podium and state your name clearly for the record so our recording secretary, Drade Geishecker, can be sure to get your name properly. And that reminds me that I should also introduce Sari Boudreau, who's our zoning administrator. After the board's satisfied that enough testimony has been heard to make a decision, a motion will be made to close the hearing. The board may then have additional discussion, and at that time, a motion may be made to either approve or deny the project. That will include findings and a statement of conditions. Affirmative vote of 4 members, supermajority is required to approve. So with that, let me say that our first, we have 1, 2, 3, 4, 5 hearings tonight, new hearings. The first one is a remand order from the court, and it includes a lot of information that's been recently sent to the board. So I'll ask TJ to read the announcement, but then I'd like you all to chime in as whether you feel you've had enough information to move forward with the hearing. Is that what you were going to say?
Can we just state for the record that the 2 associate members will be sitting
Yes.
as voting members?
Yes, the 2 associate members.
Thank you.
So John and Mark will be the voting members on this. Go ahead.
Okay. Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 40A of Massachusetts General Laws, you are hereby notified that court-ordered remand for Harold Duclos, trustee of the 315 School Street Nominee Trust of Mansfield, Massachusetts, applied to the Zoning Board of Appeals for a modification of variances 1882, 4884, and special permit 4784 to allow the raising of existing buildings and reconstruct for office and storage use on a 45,000 square foot agricultural zoned lot located at 198 Thomas B. Landers Road, East Falmouth, Mass. And the remand order from the court itself, after hearing on the parties' cross motions for a summary judgment, this matter is remanded to the Falmouth Zoning Board of Appeals for further proceedings to consider new evidence regarding plaintiff's request for a special permit.
So before taking any testimony, just if each of you could let me know if you feel like you have a grasp of the material in the file or whether... Yeah? Yeah. Okay. And I guess we'll hear from the applicant.
Right before, can I ask Sari, is, since new information is being presented or was presented by Attorney Harris, is Attorney Harris going to be present tonight, do you know?
No, this is for the board, it was remanded by the court. So she sent you all of the information she has. I've distributed it to both attorneys present.
Thank you, Mr. Chairman. I am Attorney Laura Moynihan, for the record, representing the applicant. And with me is Attorney Michael Markoff, who also represents the applicant. The request for the new evidence was a request made on behalf of Town Council. Attorney Markoff and I are here essentially, I guess, to rebut that evidence. I'm happy to present to you briefly, if you wish. It's at the discretion of the chair, an overview of the project. And then Attorney Markoff would present his summary of the position of the applicant.
What's the pleasure of the board? Yes? Yeah. I'll note that I wasn't on the original decision, so probably that would be helpful.
I'm going to ask the chair, would you feel more comfortable to continue to have Town Council at Harris here if they're rebutting her comments?
Well, it would simply be a summary of what's already been submitted in writing.
And I personally...
Yeah, that's up to the chair to ask the board.
Well, go ahead.
I personally would, there are some questions in her brief that she did give that I may or may not have questions after Ms. Moynihan, and so I would feel more comfortable in the decision-making process having her available to rebut.
So there's nothing obligating us to decide this tonight.
That's
right?
correct.
And I think since people have made the effort to get here, we might move forward and then continue if the board feels that we'd like to have further rebuttal on some.
In all fairness, if you're going to want her here to rebut possibly what they're saying, it would be advantageous for her to be here during the whole process. That's all I'm
I agree that
saying.
it would be, but I just...
I mean, she has access to the minutes, she has access to the FCTV,
Right.
so it's like, why hold up the process for a person that may have a rebuttal? I mean, she can certainly review.
So you'd be satisfied with
I'd be
that?
satisfied with moving on tonight, hearing what the client's attorneys present, and if there's any further questions that I need to ask Attorney Harris, then we'll move from there.
DJ?
Sure. Makes sense.
Okay. Okay, I think that's what we will do then.
Okay, so I'll give you just a brief overview of the site project. plans that I posted. They're in your file. One is the existing conditions plan for the property, which is here. And the second plan, closer to the clock, is the proposed conditions. This property is within the industrial area of the town. It's across from the Falmouth landfill. It's a sand and gravel, there's a sand and gravel operation next door to the east. It's just over 1 acre at 45,000 square feet. Currently, the structures on the property are there for a concrete and batching plant. You have in your file the history of all the permits, so I don't think I'll go through those unless you'd like me to, but essentially the operations for the concrete plant have existed on the site since the 1960s. The allowed hours under the permits are 5 a.m. to 8 p.m. daily, including Saturday and Sunday. So a use that's been there for many, many years with very little restriction. Mr. Manise, the Manise family owned this property for many years. It was sold in 1987, and then it was leased to Lawrence Ready Mix Concrete, who continued those operations. And then it was leased to another sand and gravel operation until it was purchased by the applicant in 2008. Since 2008, you'll see from the volume of information in your files, the applicant has been trying to secure permits to modify this use to something that I would submit as a much lesser impact for storage use within the 2 proposed buildings and a small office area of about 800 square feet. The applicant has been looking to make a better use of the site and to renovate the entire property. The storage buildings would be leased to contractors, perhaps for indoor storage or for personal storage use for a boat, for example, or a vehicle. The proposed project meets current lot coverage requirements for the district. It is in the agricultural zoning district as well as setbacks. The use that is proposed is a much lower impact use. There's less noise, there's less intensity on the site, less dust and dirt, less traffic. The planning board did issue a site plan review decision for this project and made a finding that the use would generate less traffic from the existing uses authorized we maintain under the permits. The heavy truck traffic to and from the site would be eliminated. There'd be new drainage on the entire property, which would be of benefit. The property is in a zone 2 of public water supply, which is significant to eliminating these current uses. As I mentioned, the planning board has approved the proposed project on site plan review. That was originally done in or about 2009. This slightly modified plan was also approved by the planning board administratively. The information on the traffic generation is in your file. Essentially, the peak hour trips for this proposed use are 2.9 per hour. Very low impact traffic use. The applicant has maintained that the zoning bylaw allows for modification of the use variances to allow this particular project. The standard is that the new use is not to be more detrimental than the existing uses permitted by variance. This is a different standard than a special permit standard, which is, as you know, that the new uses are not substantially more detrimental than the use that's otherwise allowed. So it's a lesser test, and we maintained all along that the zoning board could find that the new use is less detrimental. And I would submit you could find that merely by the fact that the property is in a zone 2 of public water supply, and that there'll be much less impact on the property from this use, as well as significant drainage improvements. That's essentially the project in itself. In your file, again, I know there's a lot of material there. There was an agreement by the applicant to limit what what could be stored on the property. The concern of the board was hazardous materials, so that you have all of that information. The request also was for an alternative surface parking for the project. You have that in your file. The engineering department issued a referral, and all of the concerns of the engineering department were addressed in the permit proceedings. So that's essentially the overview of what's proposed here. And with that, Attorney Markoff will present his information that's been submitted to the board.
Thank you. My name is Michael Markoff. I'm an attorney. I have an office in town, and I also live in town. I actually have relatively little to add. The new, although it'll probably take more time to do it, but the new evidence that's been presented has all come from the office of the town council. Essentially, it's a very long and detailed title search. The gist of the issue that goes to this new evidence is that in 1965, a use variance was authorized for a parcel. In 1984, there was a modification both of the use permit and a special permit was granted. That clearly pertains to our 1 acre parcel. It turns out through the materials submitted by the town council that the 1 acre parcel that's at issue in our case was actually not part of the 37 acre parcel that was the subject of the 1965 use variance. Nonetheless, in 1984, the two decisions entered that treated the 1 acre parcel as if it was subject to the use variance from 1965 and modified it to those parcels. If I may, there are 2 documents I'd just like to submit to the board. They're both copies of things that are already in the file, but I think it just might speed things up if I can just present copies. One is page 4 from the memo I wrote. There's an error in paragraph B on page 4. References building permits in fact don't exist. I apologize for that. They modified page 4 just to meet the reference to the building permits. I have copies of that.
So that would be the paragraph that starts with 4th and then says A.
Right, and then there's a B. And the B references building permits. In fact, there were no building permits. There was simply appeals to the Board of Appeals. And then the second thing I'd like to give the board, and this is in the file, but when you refer to it, it might be easier to give the copies, is a letter from Attorney Moynihan to Mr. Gore dated December 20th, 2007, which is just prior to the current owner purchasing the property. Now, the issue really is, what does one look at when one is determining what the current status of a parcel is? The letter from Attorney Moynihan to Mr. Gore recites 2 decisions that clearly apply to our parcel, and simply asks the building commissioner to verify that they do apply to the parcel. Now, in fairness, Mr. Gore has since withdrawn this opinion. I'm not suggesting he hasn't. The reason I'm submitting it, though, and asking you to look at it, is because it shows the proper analysis that we should be going through. When you're looking at a piece of land, you look at the prior decisions of this board, and you look to see what those prior decisions allow or don't allow. The theory that the town council is operating under is that that's not enough. That in addition to looking at the decisions, the applicant or the potential purchaser should also go behind the decision and basically determine whether or not the decision was properly granted or not. And in this case, the town council says the 1984 decisions were not properly granted because they didn't. They were based on the finding that the 1965 variance applied to this 1 acre parcel when in fact the 1965 variance did not expressly refer to it. The problem with that analysis, and again the problem with virtually all of the evidence that's been submitted, is that it requires an analysis that we should not be doing and I would submit this board should not be doing. And that analysis is to look at prior decisions of the board and determine whether or not the current board agrees with them or not. That, I submit, is not the proper procedure to go through. We don't have the luxury, either the people who live in this town or purchase property in this town, or this board itself, to go back through history, look at your prior decisions and say, this one we agree with, that one we don't agree with. Whether the decision was ultimately correct or incorrect in 1984, it is the decision. It's binding on the people who submitted, who were subject to it. It's binding on the property, and it's binding on everyone who comes afterwards. The new evidence that the town council is submitting goes entirely to the proposition that we should have gone, and you should go, behind the decisions of 1984, determine whether or not they were correct or incorrect, and if they were incorrect, effectively ignore them and make a new decision today that ignores the decisions that were made in 1984. I've submitted an addendum to my letter which explains my view of the law and disagrees with town council's analysis of the law. But beyond the legal question, there's also a question of public policy. Is that really a good thing to do? And I would suggest to you it's really not. You don't want people coming back here, either people who are happy with the prior decision or unhappy with the prior decision, but for some reason want to reopen it and have it redecided, in this case 30 years later. Not only does that open up prior decisions to potentially to review, but there are a couple of problems. First of all, there's no real procedure for it. As I suggested in the letter I submitted, there has never been a hearing devoted to the question of whether to reopen the decisions that were made in 1984, and that's not the purpose of the remand hearing. There's no procedure for doing that. There is no procedure for asking the board to reopen a decision that it made 30 years ago. And what this issue does is it leaves in doubt whether or not we can rely on your decisions. Whether we agree or disagree with them at the time, they are the decisions of the board. We have a relatively short period of time to appeal them. If they're not appealed, they are final. To take away the finality really puts both an enormous burden on people seeking to use land, but it also creates an enormous degree of chaos. That simply is not a good way to proceed. And so that, I think, is really the policy issue. Again, we submit that as a legal matter, this board is bound by its prior decisions. But as a policy matter, you should honor your prior decisions because that's what everyone else is relying on. And that's the sum of my comments tonight.
Okay, this would be the opportune time for the board to ask any questions they might have. Mark?
I'll start. Attorney Markov, good evening. You're aware of the previous special hearing that got remanded back to us from 2013?
Yes, that's
correct.
Yes.
Are you aware of whether or not town council did this title research during that?
No, the town council is clear that the title search was done in preparation for a motion for summary judgment in the Superior Court and was submitted, essentially the materials that have been submitted to the board were taken, were included in the materials that were submitted by the town council to the Superior Court. And they were represented to be new evidence that had not been considered by this board. And one of my complaints was that because the evidence had not been considered by the board, it should not be considered by the court. And the court said, well, in that case, I'll send it back to the zoning board. The zoning board can consider this new evidence, and then I'll know what they think about it. So this was new evidence. This was not presented in the prior hearing.
So my next question coming from that would be, is it your impression that that type of protocol by the town council's office is, as far as title research on various hearings, not necessarily this one, but only triggered by a Superior Court action?
I'm not sure I'm following the question, so maybe you can...
I'm basically asking whether or not town council office research, as it exists today and has been done and provided to the court for new information. Are you aware that town council does this only as a a mitigation per se triggered by this? Or do they typically do this as a standard protocol? That they just didn't do, I mean, this question should be to Attorney Harris.
It really,
but-
all I can do is my experience from having litigated cases, both supporting and attacking decisions of this board. I have not seen that before in terms of a title search. I have seen other instances where, particularly in the last couple of years, where the town council has attempted to introduce new evidence in the court case that had not been introduced before the zoning board. The one matter I'm thinking of, the court basically didn't take that in, did not base its decision on that information. So as far as I know, they did not. But I think if you look at the volume of the materials, I would assume that the town council does not do that in prior.
As a matter of
decision making.
practice.
Yeah, as a matter of practice. But whether they do or should is a position for that office.
My next question is a little bit more specific. Attorney Monahan had mentioned in her review, and correct me if I'm wrong, 1965, when that use variance was applied for, everything identified or pointed to only 37 acres. You, in your testimony, just said that it did not expressly identify the parcel as far as, you know, what's going to be identified as 37 or 51 for a use variance. So could you explain the confusion there?
If I can. As I understand it, actually, I'm going to ask Attorney Moynihan to address that issue. Because I think her knowledge is probably better than mine on this. But my understanding is that if you do the title, that the 1965 decision, I'm doing this from memory, I believe it does refer to 37 acres, but I'll ask Attorney Moynihan to confirm that. And that the issue was, and if I misstated this, I'm going to try to correct it, the issue was whether this 1 acre was within that parcel or not. The records that I've looked at make it, there leaves some ambiguity as to whether the 1 acre parcel was or was not part of it. And I think that may account for why the 1984 decisions included the 1 acre parcel, which in turn was part of a 13 acre parcel. Because I think there might have been some confusion in the record as to what specifically was referred to. In fairness, I believe the town council's position is that if you look closely enough, you can figure out what the 37 acres were. And you could have done that in 1965 or 1984. So I think that's their position.
Just to follow on, while Attorney Monahan looks at her records, you had mentioned a sense of ambiguity with regard to identifying. In your opinion, and you sought out town records, or did you?
I looked through the records of the prior, well, I think they were all, I looked at the prior records of this board, and in one particular instance, for instance, and I believe it's the I want to say it's the 1965 one, but it might be a later one, which refers to the area being shown in a plan outlined in blue, and there is no plan outlined in blue. So there's a plan, but it's not in blue, and is that what they're referring to or not? So that's where the ambiguity comes in. And I believe the town council makes reference to that in her letter to this board, that the records are not perfect, and they're not.
Did you want to follow up at all? Or
Yes. I think that's specifically addressed in the memo. It says the 1965 variance references 37 acres of land located adjacent to locus. The use variance was granted to Jill Manise and Adeline Manise on May 13, 1965. Pat Harris mentions that in her memo. The locus at issue was originally part of a 12.04 acre parcel, which adjoins the 37 acre parcel. There's no evidence showing whether or not the Manises had been using the 12.04 acre parcel prior to that date. The ZBA's decision in appeal number 1882, which is the 1965 application, references a plan, quote, "plan filed with the application indicating in blue the exact location of the above-mentioned purpose," end quote. The file maintained by the ZBA does not appear to contain any plan with any area in blue. Consequently, it is not possible to determine whether the 1965 use variance included some or all of the 12.04 acre parcel.
That's all I have for now.
If I can just
Okay.
comment, we know where the 37 acre parcel is, we know where the 13 acre parcel is, we now know where the 1 acre parcel is, but it's not always easy to figure out which decision is referring to what. We know that by 1984, it was 51 acres, and the 1984 decisions apply to everything. So that's pretty much the status of it. The town council's title search makes clear, and we agree, that the 1 acre parcel was not part of the 37 acre parcel. And you can infer from that, if you want to, that's what that the 37 acres is what the 1965 use variance was referring to, but it's not with certainty. There is some ambiguity.
Thank you.
TJ?
Yeah, I guess either attorney can answer this. With the affidavit of the building inspector recanting his opinion, I mean, it's pretty commonplace for us to receive opinions and referrals from the building commissioner regarding all sorts of projects before this board, but it's not too often that we see him actually recanting his statement. I was wondering if you could have any further comment on his affidavit.
As I understand it, the affidavit is based on the title search. So he's saying that once he was shown the title search in Medved, it looks like he may have been involved in the title search, although I would give Attorney Harris the credit for doing it because it was a well-done job. But I believe he's saying that his opinion has changed because he's now gotten the title history.
So you think it's perfectly valid for him to recant his earlier statement?
Well, that's a little more difficult question because the issue is not so much what his opinion is, because eventually it's your decision that counts here. The question is, what is he basing it on? Is it appropriate after this board has made a decision for the building commissioner to then say, aha, I've discovered new evidence and now I'm changing the opinion that I expressed previously? That I think gets into the same issue of what can we rely on, what we can't rely on. But on the other hand, if the building commissioner says that now that I've reviewed this evidence, I have a different opinion, I think he certainly can express that he has a different opinion. I'm not suggesting that he doesn't have a different opinion. So how you deal with that, I think, just gets into more of the complexity that this case raises in terms of what can people rely on, what people can't rely on.
I think it's important too, just to add that in this process of going to the building commissioner and seeking out these determinations, it goes further to what Attorney Markoff is saying, that was done prior to the applicant purchasing the property. And people do that for a reason, so that they can have some sense of knowledge and certainty that they can acquire property and do certain things on the property. So those opinions are relied upon by purchasers in good faith. So that's an important policy issue. In reviewing those permits and asking for that determination, that's essentially what we were looking for. We were looking for the assurances that these uses were valid and legal, and then they could continue on the property. The building commissioner does and has revoked his opinions in cases that I'm aware of where new information comes to light, such as an error in an assessor's record or an error in some factual piece of data that somebody supplied to him, where he's opining in his discretion as to, say, the buildability of a parcel. And in that opinion, he's relying on factual data. Here it's quite different, I would submit, because he's looking at permits that have been granted and that clearly state what land they apply to after the fact. So we disagree that that's a factor, quite frankly, to recant that opinion, because it's not something that could change anyway. The board had already made that decision. It was a final and binding decision.
John, anything?
Not right now, no.
Ed? I have a couple of questions. And again, I wasn't on the original case. The bylaw under which the 1965 use variance was granted has been extinguished, is that correct?
Excuse me.
Yes, it was the former so-called 27H bylaw that was repealed in 1979 when the new Falmouth zoning bylaw, I say new, but I mean completely revamped bylaw was introduced that brought forward the language that you see today for modification of use variances. Also, that former 27H language in the old bylaw had the ability for the zoning board to put conditions on those old use variances, such as limiting them to time or limiting them to the current owner of the property. All of those provisions were repealed.
So what's allowed today? What's available today?
What is available today is use variances aren't granted anymore under the current bylaw. If that's your question.
So in 79, it's not, and forward, it's not possible to get a use variance.
Correct. But you can modify an existing use variance. So
Okay.
that right for those old 27H permits was preserved for people that were using them and relying on them to come forward to the board and change them, which the board has done in many instances
Now,
around town.
According to your testimony in 84, the board essentially extended this, and that's after the bylaw had prohibited such use variance to a second parcel, which was not included in the original use variance decision. Is that right?
But the bylaw does allow for extension of them. So somebody coming in who has a piece of property that's in an agricultural district after 1979 and does not have a permit on it already, coming to you, the current bylaw doesn't provide for them to come to you and ask for a new use variance. But the bylaw does allow for extension or modification.
Extension, meaning extension to other land, not included in the original?
It could, but modification incorporates all of that. So in this particular case, however, it's not only the 1984, it's prior to the change in the bylaw in 1979, the uses on this adjacent parcel were permitted. There were decisions of the building commissioner, there were extensions of the variance to this
I'm not
adjacent
debating
parcel.
that. I might not agree that extension and modification imply that you could extend, you could, in theory then, couldn't you buy up all of the land in the town if you had one parcel that had a use variance? You could have that use variance everywhere.
Well, again, you have to look at the standards of the bylaw, okay? So, the specific language of the bylaw is that the owner can apply for an alteration, modification, or change of use of the use variance. That's in section 240-204.
Right.
So that,
But I think that implicit in that, it must be on that parcel where you have a use variance.
correct, but the position of the applicant is that those uses were already ongoing prior to 1979 on the adjacent parcel and had been approved. The 1984 permit is the first indication in writing from the zoning board of that. But you have the building permits issued in the 1970s. You have the usage going on that property. So there were prior determinations being
So
made.
those were complying?
Yes. So those determinations had been made prior to 1979, which is in your material.
Did the 1984 decision have any kind of time limit associated with it?
I have to check and see. I have to check that for you. Okay, so under section 240-204 of the bylaw, it says, "No variance may authorize a use or activity not otherwise permitted in the district in which the land or structure is located. Provided, however, that such variance, if properly granted prior to the date of adoption of this chapter, may be altered or changed or extended," so as identified below. So, and then the bylaw goes on to give you the standards for
Right.
determining that. So to answer your question, though, it doesn't mean that anybody can come to the zoning board and, do whatever they want. It has to be something that meets the standards of the bylaw, and it's subject to approval of the Zoning Board of Appeals, which we maintained occurred in 1984. So the board looks at the standards of the bylaw, they look at the impacts of the neighborhood, et cetera.
I'm
and they
curious
make that
about the
determination.
1984 decision, whether that stipulated any,
Okay, so it's a very simple decision, 2 pages. This was an addition application for permission to construct an addition onto an existing building on the property. Application papers were filed. Board of Appeals, after carefully considering all the facts and evidence presented, votes to grant, etc. The board finds the site to be adequate in terms of size and also suitable for the proposed addition. The site is quite large and has the existing concrete business operating on it at present. There will not be an adverse impact on the neighborhood's visual character by allowing the addition, as it will be located adjacent to the existing plant. The existing plant is located in the lowest portion of the lot and is set 125 feet back from the road. There will be no impact on traffic flow and safety, as the addition will not create additional traffic. It is to be used for storage.
is this the one that cited the incorporation of the 13 acres into the 37 for a total of 51 acres? That's the...
That, we'd have to look at the application. There are a lot of files here.
You're telling me. We tried to go through them all.
I know. Was on application had the acreage in it. So I'll give you, this is a summary that I did. Okay. So, my summary, because I had gone through the title and the applications, I mean, all this information is in your file, but I'll just give you the gist of it here. At variance petition dates in 1965 and 1968, 37.05 acres and 12.04 acres were commonly owned by Jill Manise and Adeline Manise. Okay, those are the two parcels next to one another, the total 51. Parcels remain in common ownership until 1975. In 1968, appeal number 2175, the town recognized the 12.04 acre parcel as part of the sand and gravel operation. 1968, appeal number 2175. Both the 2.04 acre parcel and the 38.77 acre parcel are referenced in appeal 2175. As condition 1 states, it applies to the entire 51 acres owned by the applicants Adeline and Jill Manise. Okay, so that was in 1968. That's what I'm saying, it's prior to 1979 even, that the town was recognizing the 51 acres, the two parcels, as part of this total operation. Appeal 2175, which was in 1968, required submission of a plan for approval by the zoning board. Note the references on the plan to the existing plant areas off of the 38.77 acre parcel located on the 12.04 acre parcel to the west. So that plan is in your file in Appeal 2175, 1968. That was submitted. Okay, there's a recorded plan dated 1978 showing plant operations from the 38.77 acre parcel onto the 12.04 acre parcel, the spillover. Note the location of the gravel pit and structures commonly used between both parcels. That was 1978. Okay, so building commissioner's determination dated May 3, 1988.
But just backing up for 1 second, but there hadn't ever been a separate application for a use variance on the 12.9 acre piece. It had just been assumed that one extended to the other.
Well, I'm not sure that if we can really answer or know what was assumed or not assumed. All we know is
Well,
what
we can know whether there was a separate application.
Well,
Was there?
in 1968, the application was for 51 acres. That's in the application. That was in 1968. So we're not assuming that. That's what was referenced on the application.
And that was for a use variance?
The town that was for, I don't know exactly what that was for. It might have been part of the sand and gravel, some kind of sand and gravel additional operation. But in that application 2175, we can pull it out. As condition 1 states, it applies to the entire 51 acres owned by the applicant. So that was a condition of the board.
Application 2175.
5.
Okay.
Okay? And then in that same application, the board required a plan to be submitted. That plan showed both the 38.77 acre parcel and the 12.04 acre parcel. So I think it's pretty clear as of 1968, the board was modifying and extending that use variance to that entire 51 acres. The subsequent permits just reaffirmed that, including the 1984 permits. In 1984, the zoning board issued an approval to construct the addition, which I just went through. In 1985, issued approvals to construct a cement hopper, storage building, and garage, 1985. all those constitute determinations of the use on the 12.04 acre parcel and approval of any extension of use.
Those were zoning determinations, not building commission.
Zoning board decisions, 1984 and 1985, approving additional development on both of these parcels. So, and that's the applicant's position, that, you know, there's a clear history here, even before the 1979 bylaw change that repealed the old 27H, that the zoning board was recognizing these operations and allowing them, approving them on this entire 51 acres of land, including this locus. So, do you want me to see if I can dig up that application for you? It should be there.
Are you looking at the 68? The 68 was just a permit, and it's the one that lapsed after 20 years. And it's in your, what tab number is that? Yeah.
1988.
4, tab number
Tab
4.
Under Attorney Harris's.
That was for the sand and gravel.
But there's dating, as that's the first time it said 51 acres.
Right.
That permit was only good for 20 years.
Right, so that's what I'm trying to establish. So that would have lapsed in 88.
88.
Yep.
27 years ago.
Right. Sari?
Yeah. You stated that in 65, the use variance was given, and at that point, you didn't know if the Monises used the 12 parcels adjacent, the 12-acre parcel adjacent, but the Monises didn't buy that parcel until 1966, so they weren't in ownership of it, so it couldn't become part of that use variance without an authorization attached to that use variance.
Well, what we don't know is who was using that parcel between the time that the 65 variance was granted and the time that the purchase closed. It's true that the Monises did not have record title to it. Whether they were using it, or whether they had a P&S agreement, we don't know.
That would have been part of the record, I would assume.
Well, a purchase and sale agreement would not be recorded anywhere. So, and those, you know, the people who were involved in that transaction are not available. So, you know, the title did not pass until, I think it was January 1966. It did not pass until after the use variance had been granted. That's absolutely true.
Okay, and under 27H, Laura, you mentioned this, the word extension. Do you believe that means land or an extension of time, since that was allowed as a condition under 27H? The word extension, because it's not in 204. But yours, by what you said, by the words you're using, extension, you mean they could extend over into a lot that the use variance wasn't granted for initially, correct? Is that what you mean, or is it relevant to time, the word extend? Since they could condition a certain amount of time limit.
I think it could be either, quite frankly. I mean, when there's nothing limiting that language, it also says, it uses the word alteration.
So when they use the 51 acres in 68, you feel like that was, even though that wasn't a modification of the use variance, it was a permit, that allowed that extension onto the 12 acres, which later expired after 20 years?
Well, that language wasn't imported
That's clear,
into
isn't
the
it?
bylaw
Once you
until
bring it up.
1979. So
Right.
we're dealing with the period of time between 1965 and 1979 and looking at that permit history. When you look at that permit history, I don't think the question of any extension is really necessary, whether or not that authorizes it or not, because what was going on and what had been approved up to 1979 clearly shows that the board was approving all of these operations on both parcels. Okay?
Which,
So,
the 51 acres is mentioned in 68, and that's the permit that was expired in 20 years. So that kind of negates, does it not, possibly?
No, because it allowed for extensions of it. If they were looking for continuing sand and gravel mining, they could apply for extensions of it. But regardless,
But they
prior to that expiration, there were additional applications to the zoning board in 1984 and 1985. So the
Which-
expiration of it, I don't think is
It wouldn't
relevant.
have expired until 88. And were those requests in 84 use variance modifications?
They were considered at that time to be modifications of the prior permits. And again, we went through the hearing, because it's a very difficult issue. At that particular time, the town was treating them as special permit modifications of prior use variance grants. That has since been corrected so that the procedure is to apply for an actual modification of the variance. But for some period of time, those types of approvals were being called special permits.
How was that
Under the-
corrected?
The town stopped doing that. So
So
along
then
the way,
your
there was,
decisions changed. Okay.
that the town stopped doing that because it was not, somebody along the way said, we should be approving these things by specific modifications to the use variance, rather than looking at these as non-conforming uses that we're modifying by special permit. But regardless of that, from a procedural point of view, as Attorney Markoff has said, none of those decisions were ever appealed. They're final and binding decisions. The owner, the applicant, the town, the public is entitled to rely on them. So
Were there building permits issued without special permit or use variance modifications?
there were in the 1970s.
So the applicant relied on the building inspector, as they did in the narrative that you gave previously, his testimony, or not testimony, his affidavit that you asked him to sign in 2007.
The prior building commissioner, John Alcorn,
No, I'm talking about Eladio's decision as well, or affidavit that you had him sign in
the
2007.
applicant,
Mhm.
before purchasing the property, yes.
So
And
they
as-
didn't take it upon themselves to get an attorney to do a title search, which is the usual way to do things before they bought the property.
Yes, they did. But again, because of the history of the permits, with the permits having been modified over the years to apply to this particular property, that's what people rely on. They
Okay,
have to
okay.
be able to rely on the fact that those permits were properly granted and for this property.
I think John has one point, which I think he'd like to bring up and ask you about.
I have a question on your interpretation of 240-204 and the modification and extension. Did you state that that would mean that could extend to the 12-acre parcel?
My statement is that prior to the adoption of this bylaw in 1979, the extension or the addition of this 12-acre parcel was already a done deal. It was already done. The record shows that there were permits granted by the zoning board and the building commissioner approving the extension or alteration of this use variance to the parcel that you see before you.
But you say that extension or modification, alteration, or change of use implied that you could add another parcel of property to that. But But my reading of section B says, such request should only be for modifications, alterations, or changes, or change of use, and not for an extension in physical area.
Right, that's what it says.
Isn't that the exception? Then it means it does not extend to that other
So I
12?
think.
That's
if-
correct.
So what you would argue is that this is the current bylaw.
Right,
In today's world, you could not ask to extend a existing use modification physically to a larger parcel by adding to that parcel.
that's what the bylaw says.
Okay,
Such
we agree on that.
Such modifications, alterations, or changes shall not apply to any land not previously covered by a properly granted variance.
Okay.
That is in
But
240.
your contention is that prior to the new bylaw, that was okay,
Yes, and it was done in this case.
and it was done. And is the first citing of the full 51-acre parcel in the 1968 decision?
I don't know if I can answer that without
Okay.
going through the material.
Because what I'm struck by is that provision 1 of the decision says, this permit shall cover the entire area of the property presently owned by the applicants on Thomas B. Landers Road, being approximately 51 acres, but subject to the restriction that the condition land shall be worked in parcels of not more than 10 acres on a plot plan that will be submitted to the board for approval. And 2, importantly, the permit shall be enforced for 20 years. So after the 20 years, then what?
Then the applicant can apply for extensions if they so desire.
And did they?
I don't believe they did. The record doesn't show they did. But the point is, prior to the expiration, the stated expiration in 1988, there were additional approvals issued by the board in 84 and 85
And did,
for this particular locus.
right, but implicit in those approvals might have been the fact that this was in force
Which it was.
and would expire in 20 years.
But that doesn't mean the decisions that were issued in 84 and 85 expire. See, there's nothing in the decisions in the 1980s that say these decisions are only issued if the other decision expires in 1988. They didn't do that.
Subject to the conditions of this
Right.
permit.
There was no exception in 84 and 85. They were simply modifying what was already there. Those 84 and 85 decisions are reliable decisions. Okay, so the 20-year limitation on this permit in 1968 is not relevant because you had prior approvals in 84 and 85. You also had approvals prior to 1979 when this new bylaw was adopted, and you had building permits issued by the building commissioner. And at that time, you had a different statute as well. You had modifications that could be granted not only by the special permit granting authority, but also by the, quote, permit granting authority, which could be the building commissioner. So it was a different time, and that's very relevant to what you're looking at now.
I guess I just have one or two more questions. Those other decisions, were they use permit decisions or were they permits to construct buildings or, you know?
Well, I think they were both. I mean, if the building commissioner issues a building permit to allow construction of a structure in 1977 or 1978 on this particular 1-acre piece of property, he's making a determination
That at the time,
that variance is lawfully in effect for that piece of property. That's the determination. The building
I
permit,
wouldn't take issue with that.
nobody,
It's just a question of whether that use was permitted after 20 years.
but I think what you're doing though is you're going back and you're saying, okay, well, those decisions were issued, but were they correct?
No,
And that's what town council's asking you to do, but we're saying is, there are statutory limitations on those decisions. The building permit was issued in 1978, there's a 6-year statute of limitation on it. You can't go back and say, well, maybe the building commissioner shouldn't have done that in 1978. You know, how was that done? How did it attach to this property? The fact is, it did. And the building was lawfully permitted, and it was built on this particular 1-acre piece of property. The building commissioner made a determination when he allowed that building permit that this use was valid and legal on that property.
Understood. But I don't know that that necessarily, I mean, that building has a useful life. If you had a business and you had gotten a permit to operate for 20 years and you discovered 10 years on, you needed to build a building to carry out that business, you might build it, figuring that it would pay for itself in the additional 10 years, but that when the 20 years was up, you'd abandon the use.
But that's not what happened here, because in 1984 and 1985, new applications were brought forward for additions to the building for construction of a cement hopper. So they were clearly expanding or altering, you know, for concrete operations, the building that had been permitted in the 1970s. So it wasn't a situation where the use was trickling down and there was an
Well,
anticipation.
they had till '88 before the use expired, right?
Can I just
Yeah.
ask? They could probably look it up, but it's my understanding from reading that the expiration is only applicable to the excavation of the sand and gravel. The batching, the screening, and everything else was not given a time limit.
I think to
And
me the
so, I
relevant...
mean, I'm throwing that out there from what I read.
Let's not
so-
get into the discussion yet.
Right. I mean, I think the board's under the assumption that the 20-year exhaustion period applies to everything that's taking place on the property, and I didn't read the information that way.
Okay. I guess the last question I have for you, Laura, is your, the use you're proposing, you know, I drove out to the property, certainly would be an improvement. Is there any other way, other than a extension of the use variance, that this could legally be done? I mean, storage of boats, for example, is allowed, but I guess this parcel doesn't meet the 2-acre minimum. Is that the issue?
Correct. Yes, and this is an agricultural zone piece of property. So boat storage, it doesn't meet the acreage minimum. There are other uses that could be permitted by right on the property. We submitted that evidence to the board as part of the hearing process, which I would submit have a higher impact on the neighborhood than the storage use. But that's why this use is being proposed. It's adjacent to an existing light industrial area. It's low impact. It's a good fringe use of the property, cleans the property up, gets rid of, you know, the cement operation that's there.
Right. What other recourse, if the board were to find that you couldn't extend the use variance, would the applicant have?
Well, do you want to answer that? The case is currently under appeal in Superior Court, so your issue, I think, is a little more narrower than that. You want to answer that?
Well, no, I think, if I understand, I think you'll have the answer other than I will, but I think what you're asking is what else can we do with the property? You know, assuming that this application fails either here or the Superior
Right.
Court and we can't do the current plan, what else can be done? So I think that's your question.
Or what could be done so that you could do what you want?
Well, you'd look to the agricultural district regulations. Do you want me to go through those for you as to what are the by right uses?
I don't think you necessarily need to do that.
Okay. Let me just take a look at it quickly.
it would still be too, I guess what I'm wondering is if it was rezoned light industrial, it would still be too small.
I think if it was rezoned light industrial, it could be used for any number of light industrial uses in the district. But that's not what the applicant is looking for.
I hear you.
You know, to do something like that obviously is, you know, would be a lot more added to the property in terms of potential uses. So right now, I mean, the by right uses would be a one-family detached home. Again, you're in a zone 2 of public water supply. With that, you're adding more sewage than what this storage facility will add. Permitted community service uses, churches, schools, libraries, museums, agricultural research institutions, group daycare homes, and child daycare centers. Those are all higher impact uses than this. Parks, playgrounds, water towers, other permitted principal uses, agriculture, horticulture, and floriculture, including farms, cranberry bogs, dairies, truck gardens, greenhouses, and natural ice harvesting activities. Those are by right. Nursery would not be allowed because it's not 2 acres. So special permit uses, private clubs, not-for-profit. I mean, there are a number of additional uses, but again, when you look at what could be done on the property, this is the lowest impact use in terms of, particularly in terms of septic and traffic. So there's also, just to sort of recap what we were talking about, in your file, there's also a determination letter from 1988 from John Alcorn, the then building commissioner, that goes through all of the permits on this property, again issuing a determination saying that there were no violations of the zoning bylaw. He talks about in 1984, he calls it a variance. The Zoning Board of Appeals issued a variance to construct a cement hopper not to exceed 49 feet in height and a storage building not to exceed 31 feet in height. 1985, the building department issued 2 building permits to add a garage and a cement hopper. 1984, zoning board issued a special permit to construct a 31-foot addition onto the existing building. I mean, these are all, again, an additional determination from 1988. This is in your file, so that is even further back, saying that the uses are allowed as of that point. That was the determination of the building commissioner.
Okay. Any other questions from the board? Any comments from anyone in the public? Board discussion, do you want to think about this a little bit? Do you
Well, yeah, I think we should
There's certainly a lot of information
rest on
to
it. And,
digest.
yeah, and there's more information that I'll have to go back and review from the various pieces that were put in the file. So I would move
And
to,
let me ask
okay.
also that, would you like to hear from town council?
Yes, I think some
definitely.
of my questions, and thank you for suffering through them, should have been directed to the town council.
Okay, so.
So I'll
continue
move
with-
that we continue.
Second.
Okay, to when? To
What's
June-
available?
I think June 11th, is that correct?
Whatever the board would like. I don't know if
You have room? and
Attorney
June-
Harris could do it on that date. That's why I asked previously if we should just wait and get a date that she could, but that's all right. June 11th, and I'll see if she can attend. June 11th or June 23rd.
Well, let's aim for June 11th. If she can't, we'll continue it again.
Is that going to give the board enough time to review the information that they feel they need to? Can the attorneys make it June 11th?
I didn't bring my calendar with me.
Like, yeah, The only thing is I can't change the date, so once the board establishes a date tonight, it can't be changed unless you continue at the next hearing.
Is it possible to just close it and ask her to submit comments in writing by June 11th for the board to deliberate on?
I think we'd like to be able to ask her
Ask her
questions.
Yeah, and you can't rebut. It's closed. Do you need a
Okay.
further date out?
No, let's June 11th.
So I'll move June 11, 6:30.
Okay, moved and seconded.
Second.
Okay. Seconded by Ed. All in favor?
Aye.
Aye.
And aye. All right, thank you for the refresher course and helping guide us through a complex list of special permits and variances. Are they here? Okay. So I'm told that there's hearing 3715, the applicant needs to drive to Providence and is wondering if we could possibly take them out of order. Would anyone like to make that motion?
I'll make the motion that we take 3315 out of order.
37.
What is it?
3715.
3715?
Yeah, Bulgarian.
Foreman, right?
No, Bulgarian.
Oh, okay.
Foreman
Sure.
would be next.
3715, yes.
Second.
Okay, all in favor?
Aye.
Aye.
Bulgarian is up. Yes, we need to read that into the record.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 40A of the Massachusetts General Laws, you are hereby notified that Kenneth Bulgarian of Providence, Rhode Island, applied to the Zoning Board of Appeals pursuant to Section 240-160A of the Code of Falmouth to allow seasonal parking in summer months for a fee on residential property at 335 Quaker Road.
Good evening.
Do the
Go ahead.
referrals.
Referrals? Sorry, Attorney Liverts.
All right.
From planning, we have no comment. From health, comment is the property owner becomes responsible for any accidental discharge of toxic or hazardous materials, and that's a few comments.
Good evening. Attorney Chris Lepers for Harry Bulgarian and Ken Bulgarian, his dad. Appreciate you taking us out of order. One of us has a final tomorrow in high school, and it isn't me, okay? It's this guy fellow standing behind me. This is the 7th time now we have appeared before this board. I think, with the exception of Suri, I think the entire composition of the board has changed. But Harry is with me here tonight. He is now 16 years old, and we started when he was 11, I believe. Essentially, what we are proposing at 335 Quaker Road is a limited and seasonal request to park some cars. Hopefully you have the plan in front of you. I checked in with Suri. I don't think there was any question about the filings. Nothing has changed from last year's application. The hours, I believe, were 9 to 7:30. 7 cars on the site. There is no signage. I am not aware of any problems with neighbors over the years, and I've been here now 7 years on this one. Initially, if you go back 6, 7 years ago, we were actually getting more cars, but we modified the plan a few years ago because there was an area of a bordering vegetated wetland. We took parking out of that area, and that's also a condition, I know, of the last few years' permits. That last hearing you had was a long one. I don't see any need for me to go on any further.
Thank you.
I'm happy to answer questions, and Harry and his dad are here tonight as well. But thank you for taking us.
Okay. Anyone on the board have questions?
No.
And Sari, we've recorded no complaints about this operation.
Not at all.
Okay. Anyone in the public have any comments regarding this application? Hearing no comments, would anyone like to make a motion?
I'll make a motion that we approve.
First, we need to close the hearing. Which you may make.
I'll make a motion that we close the hearing.
Second it.
Okay, motion to close, all in favor?
Aye.
Aye.
And aye, passes unanimously. Now, would anyone like to make a motion regarding denial or
I'd like to
passage?
make a motion that we approve 37-15.
Second.
All in favor?
Aye.
Excuse
As a
me.
finding?
Findings?
Do you want to make the same findings and
Yes.
conditions since everything is unchanged?
Yes.
Sounds
As we have in
great.
the previous, including he has
So-
to come back next year.
so that's
It's
part of
a
the
yearly
motion?
permit.
Yeah,
Part of the motion.
because we want to continue to see him.
Yes, he's getting tall.
It's good for my business too. Thank you.
What's the final in?
English and science.
Okay.
Good luck.
Okay, so we have a motion to approve the operation of this parking for a fee with conditions and findings as per prior decisions. All in favor?
Aye.
Aye.
And I as well, so that passes unanimously. Thank you very much.
Good luck.
Thank you.
Good luck, hope you have a great season. Good luck on your finals.
Ken, can you take the 5 minutes?
And I have a request for a short recess, so we will take a 4-minute recess.